Welcome to The Explainer. Now, if you're gearing up for the Queensland Bar exam, you know the law of evidence can feel like a total minefield. But don't worry. Today, we're handing you the map. We're going to break down that critical distinction between facts and evidence so you can build arguments that aren't just correct, but are genuinely compelling. You know, this quote, it just hits the nail on the head. It's a trap so many new barristers fall right into. When you confuse these issues, you get muddled arguments and critical errors that can literally sink a case. But here's the good news. Once you see the framework we're about to show you, you'll sidestep that confusion entirely. So that's the big question, right? How do you actually do it? Well, together, we're going to build a mental toolkit. It's one that's going to help you construct arguments that are clear, logical, and most importantly, persuasive, right from the ground up. Okay, let's dive in. First things first, facts in issue. I want you to think of these as your case's North Star. Seriously, identifying them correctly is the absolute first, most crucial step because they're going to guide every single thing you do from here on out, every piece of evidence, every question you ask. So what are they? Well, this is the legal battleground. It's all the facts the plaintiff has to prove to win, plus any facts the defendant is relying on for their defense. And these are defined by two key things. First, you've got the substantive law, torts, contract law, that kind of thing. And second, and this is absolutely crucial for you in practice, it's the pleadings. The pleadings are what take this huge universe of possibilities and narrow it right down to what's actually being fought over in court. Let's make this real. Take a simple personal injury claim. The law of torts tells us the plaintiff has to prove these core elements: duty of care, breach, causation, and damages. Boom. Right there, those are your main facts in issue. Now, what if the defense comes back and says, okay, we admit negligence, but we're fighting you on the amount of damages? See what just happened? The pleadings did your job for you. They've narrowed your focus. You now know exactly where to aim all your evidentiary firepower. All right, next section. Your evidentiary toolkit, the building blocks of proof. Okay, so you've found your North Star. You know what you need to prove. Now let's crack open the toolkit and see what you're going to use to actually prove it. So here we have the principal items of evidence. We're talking about 5 fundamental categories: testimony, documents, hearsay, real evidence, actual things, and circumstantial evidence. Everything, and I mean everything you use in court, whether it's a person talking, a piece of paper, or the literal smoking gun, it's going to fall into one of these buckets. But, and this is a big but, one of these is absolutely central to all the others. They're not all created equal. There's one that's foundational. It's the key, really, that unlocks pretty much everything else. And mastering this one, it's completely non-negotiable. And that central piece is testimony. And here's why it's king. Think about it. How does that crucial contract get into evidence? A witness has to get in the box and identify it. How does the judge understand why that damaged piece of a car matters? A witness has to explain it. Testimony is the vehicle. It drives almost everything else right into the courtroom. Now we're moving to the next level. Look, understanding the main facts in issue, that's fundamental. That's Bar Exam 101. But mastering collateral facts, that is what separates the good advocates from the truly great ones. This is where the real art of advocacy lives. So what are they? These are subordinate or collateral facts. They don't prove the main case, but they affect one of two things: a witness's credibility or the admissibility of other evidence. Think of them as the facts about the evidence. They don't prove negligence, no, but man, they can be just as important. They can show a key witness is biased. They can get a crucial piece of your opponent's evidence thrown out entirely. They're the gatekeepers of what the court gets to see and believe. And this comparison here really lays it all out. Main facts. That's about proving the core elements of the case, like was the defendant negligent? Subordinate facts, that's about credibility and admissibility, like is this witness biased? One is about winning the war. The other is about controlling the battlefield. And trust me, if you get this right, a single sharp cross-examination on a collateral issue like bias can completely dismantle your opponent's entire case. All right, our last section, and this is a big one, a critical pleading warning. Avoid this common trap. As we wrap up, I want to leave you with a super important practical piece of advice. This is a trap that catches so many junior practitioners, but you know what? After this, it is not going to be you. Okay, here's the warning. I need you to be absolutely crystal clear on this for your practice. Verified pleadings are not evidence. I'll say it again. A statement of claim, a defense, even one that's been verified with a sworn statement, it is not evidence in the case. It defines the issues, sure. It makes admissions, absolutely. But it does not prove the truth of anything written. And just think about why this rule has to exist. Imagine the chaos if pleadings were treated as evidence. The whole system would fall apart. You could, in theory, cross-examine a party who was never even called to testify. A plaintiff could rely on their statement of claim and survive a no-case-to-answer application without ever giving evidence in person. The consequences would be, well, totally absurd. And that's exactly why the rule is so firm. So when it all comes down to it, the real question isn't just what is evidence, it's what story are you going to build with it? This isn't just theory for your bar exam. This is the blueprint for building clearer, more logical, and way more persuasive cases for your future clients. The question is never just, what's the evidence? It's, what story will you build with it? And how will you make sure your story is the one the court believes? Master that, and you are well on your way.